There are concerns that the Senzo Meyiwa case may have hit another snag following the sudden death of a key state witness. Former Gauteng Head of Detectives Philani Ndlovu passed on after a short illness. Ndlovu said to be one of the first people to arrive at the scene after the soccer star's murder back in 2014. News 24 is also reporting that he had additional information about that fateful night when Meyiwa died, and this information was going to form part of his testimony. So let's make sense of the legal implications moving forward and speak to legal analyst Mpumelelo Zikalala, who joins us now via our video link. And it's great to speak to you as always, sir. Thanks for making time. Let's begin by just, I guess, ascertaining how much we know about how important Ndlovu's testimony actually was going to be.
It's very important. Just remember, he's one of the first people that were on the scene. So in terms of the things that were there, the layout of the scene, what was found, it's very crucial and very important. Another important factor would be the people that he found there, especially the ones that were in the room. What was their reaction? What did they say to him? How did they feel? How was their demeanor at the time that whole particular process was taking through? Most importantly would have been their responses to him when he posed certain questions. And the other important factor is what exactly did he see? Let's remember that the first witness that got in simply said, I was being shown by this person where I'm going to find the relevant things in which I would need in my forensic investigation. So for him, it is very important that he was supposed to give this particular information. But another important factor is this one. The information which he is saying that he was going to give when he's giving his testimony, why wasn't that particular information recorded so that the defense would be able to have sufficient time either to dispute it or to confirm it? And why keep it behind the scenes up until the last day? Because the unfortunate thing now is that he has passed on and he's going to take all this information with him to the grave.
Yeah, and that's the question I was going to ask next. I mean, surely there is some documenting process that takes place, because outside of witnesses potentially dying, they could also be met with several other traumatic events preventing them from taking to the witness stand, as it were. It doesn't mean their information should be obsolete.
Even illness would then kick in. That is why in criminal investigations you have affidavits that are going to be deposed to by the witnesses. Those affidavits are exchanged during the pre-trial process, and the defense would have a rough idea of what this person is going to say. And that is what you use in certain instances when a person has died on. Just remember that we have the Criminal Procedure Act, which guides as to how procedures, the criminal matters are supposed to be processed or how they should be conducted. If you look at Section 214 of the Criminal Procedure Act, allows for certain information which was obtained within the preparatory stage to be used at a later stage when a witness is no longer available. It was designed exactly to cater for this type of instances. Now, the danger or the problem that you have when a person did not depose to this information, or the information that is deposed to is not enough, you can't use that at a later stage. Another thing which is a worrying factor that we always lament on is this. The quality and the quantity of the evidence is crucial. And the longer you wait up until a matter is called upon to court, the longer you wait up until you are able to deal with the matter, that the quality and the quantity diminishes. It does not only favor the defense, even the state has a problem, because that means the burden of proof which hurdle that you have to go over. You can't do that when you have certain information which is crucial. Again, for the defense, you can't cross-examine that particular individual. So anything which are going to bolster your case and be able to prove that your clients are innocent is no longer there. But the most people who are going to suffer in this particular case is the family. Yeah. Because they are the ones who are going to say, we are going to go out of this courtroom without having found out the truth about what happened to our loved one, which is crucial. That's why we are participating in this whole process. We want the truth. We want to bring closure to this matter. And if key individuals which are able to answer our questions are no longer there, one, justice will not be served because the perpetrator has not been found guilty. Secondly, we are not going to have answers as the family, which is very detrimental in the healing process of the family.
Yeah, interestingly enough, Advocate Malisela Tefu, who we know was arrested controversially inside court the last time this matter was sitting in court, he apparently has written a letter to ask that the case actually sit earlier. In other words, to move the postponement date to before the 30th of May, which is when that matter is set to resume. And I'm raising this because of the reasons he's asking for this. One of the things he mentioned is that he feels there is a concerted effort to actually sabotage his work and the state's case. It's difficult not to see Philani's death, or Brigadier Ndlovu's death, in light of that letter.
Maybe to add on the fact would be to check how many other witnesses have demised since the start of this case. Let's also take into consideration that we have waited for almost 8 years for this matter to start. So it calls upon the presiding officer, the judge in this case, to say, I want to listen to your concerns. You have the constitution which enables me or which gives me a duty to make sure that the trial must start and end within the shortest amount of time, precisely because we want to prevent this type of situation. Secondly, I don't want any unreasonable delays which are going to happen in this particular case. The Criminal Procedure Act guides me as to what should I do in order to prevent those unreasonable delays from taking place. So it warrants that Advocate Senzo be given an opportunity to present his submissions, and we can then work together, or the state with the defense can then work together in terms of saying, what can we do so that at the end of the day we are able to get as much evidence as we need into the record so that it is decided. The one thing in which all parties want at the end of the day is for the case to start and end within the shortest amount of time, the truth to come out, and the only way in which the truth is going to come out is when witnesses go into the witness box and they're able to give examination chief to cross-examine and re-examine. So it's crucial that he at least be given an opportunity to present his case and to state and provide maybe possible solutions on how we can curtail this particular thing from happening again, especially because you have tangible evidence of witnesses passing on when they haven't provided the information which is required.
Yeah. For better or for worse, I mean, this is, I'm sure, not the first time that a key witness dies in any matter at all. You would have imagined that, people would have learned the lesson by now to be able to prepare or shield against the kind of setback potentially that the state has suffered. Would it be circumspect for the state moving forward to begin the process of recording whatever evidence other witnesses have, so as you put it, to prevent something like this again from taking place?
It ought to be done, because that's how you are able to prepare for your case. That covers two instances. It covers the instance where the investigating officer passes on, instances where the prosecutor passes on and is changed, so that at the end of the day, you are able to have that valuable information being recorded down. The issue of admissibility of that evidence, what the person has demised, because you can't cross-examine them anymore, is another issue on its own. However, at least you are able to present it to the court and be able to submit it. Whether the court is going to choose to accept it or not is something that can be done at a later stage. Another advantage of that is that there are certain admissions that can be made between the parties, either using Section 220 of the Criminal Procedure Act or 212 capital B, which then allows for admissions to be made and certain things to be considered by both parties who are providing evidence. So it is absolutely crucial for the state to start using these processes, especially the law enforcement officers, so that we don't find ourselves in a similar fashion. Maybe it also goes back to what this case is going to seek to do, the Senzo Meyiwa case, is to put a spotlight on the way in which criminal investigations are being done, the capacity of the state to be able to do those criminal investigations in a way which will then guarantee a conviction. Because it is a test case to test, are we really doing things right as the law enforcement agencies? If the answer is yes, then let's continue. If the answer is no, then we need to put in preventative measures which are going to make sure that we preserve this type of evidence that you require in the long run. It will not only help this case, but many other cases. The one that quickly comes to mind is all the criminal cases which are going to come as a result of state capture. Let's remember, when we speak of state capture, it's a number of years worth of investigation, and probably the last 4 years in terms of the evidence which is going to be provided. We do not want to spend as much time and much resources. Only at the end of the day, the evidence that you have can't be used at court because you didn't collect it correctly, or it can't be used at all because the person who's supposed to present it is no longer there.
Yeah, we've heard from some whistleblowers in the state capture matter saying that, it seems there's still an interest in ensuring that there aren't prosecutions in those matters, given how evidence that's before us is currently being treated. Mpumelelo Zikalala, always great chatting to you, sir. Thank you very much indeed for your time. Mpumelelo is a legal analyst.